Good morning, students. Today I am talking about one-person company. One-person company is also a type of company, and this is one-person company is not proprietorship. It is not so proprietorship. It is a one-person company, incorporated, initiated, started by a one person. Or this is also one of the kinds of company as per the Companies Act 2013. So the meaning of one person company means a company which has only one person as a member. So one person act as a member of the one person company, and this is a company in which one man holds practically the whole of the share capital of the company. So the all the capital contribution is by one person. So one person form an idea to start a company, initiate the idea to start a company, do all the legal formalities in respect of the incorporation of one person company. But this is not as similar to proprietorship. Proprietorship is different. So sole proprietorship is different, although it is also done by one person, but with the assistance of a manager. But this is a company, and this is run by one person, functioning by one person. All the responsibilities, all the whatever the routine activities, all the things are done by one person. This is a one person company. So all the share capital, whole of the share capital holds by one person. This is a company in which one man holds practically the whole of the share capital of the company, and this is in order to meet the statutory requirements of minimum number of members. Some dummy members like his wife and son holds one or two share each. So the company, whether it is a public limited company or private limited company, this is a minimum requirement is 7 in case of public limited company, 2 in case of private limited company, and minimum is 1 is required. At least we need some person. So to start a company, to form an idea. Idea generation is on the part of the promoters of the company. So here is only one person who initiate the idea, start the idea, and to take all the pains in regard to incorporation, filing of all the returns with the ROC, and doing all the legal formalities, appointment of legal advisor or solicitor for the to do all the legal formalities in respect of incorporation of one person company as per the requirement of the Companies Act 2013. So but we need some members, we need some dummy members, like his wife and son holds 1 or 2 share each, but maximum contribution in capital of one person companies by one person. But we need actually the company, the name itself, company may association a person, so we need persons to run the company, but capital contribution is by one person. We need persons, we need employees in the company, we need directors in the company to take important decisions of the company, the board meetings of the company, but the capital providers in this case, one person holds the maximum number of shares in the company, and that person is called the owner of the company, promoters of the company, founder of the company, and that person can also hold the position of the director of the company, can conduct meeting in itself, hold a meeting, issue a notice of the meeting to himself, conduct a meeting, and one person in person, proxy is not, because the one person proxy is not there, you are the only one person in the company, you have to conduct meeting with yourself, so proxy is not there, but because you have to present in person as per the code of the meeting, but in the case of a public limited company, at least 5% must be present in person, not in proxy, to attend the board meetings of the company. but we need some members. We need some members to run the regular affairs of the company, to run a big company, whether it is big, small company, medium company, big company. We need persons, we need individuals, we need experts to run the company. But although this is a one-person company concept, so only one person as a member in the in, on the records of the company. This is a one-person company. So we have in this company type of company only one person can act as a member of the company. Then, as per the definition given in the Companies Act 2013, so as per Section 3, subsection 1, Clause C, one-person company is considered as a private company. Only a natural person who is an Indian citizen and resident in India is eligible to incorporate it. So, in corporation, there are certain criteria, there are certain conditions. Only those person can incorporate it itself into a one-person company. And this is a type. This is not a one-person company. Is not a public company. This is not. They are not providing their shares, issue subscriptions of their share to general public. This is a private company. So only natural persons, because the company is an artificial person, company run by its members, by its directors of the company, whatever capacity they are in the company as independent directors, as dependent directors, as executive, non-executive, they are the natural persons. So only the natural persons who run the affairs of the company. So the criteria is the natural person must be Indian citizen, because this is an Indian company. This is not a foreign company. This is not a multinational company. This is an Indian company. So who is an Indian citizen and resident in India is eligible to incorporate it. So these are the eligibility conditions applicable to form into a one-person company. For the purpose of incorporation and registration of one-person company, the natural person must be Indian citizen. That is the essential criteria, and must be a resident of India, and that makes that person eligible to form into a one-person company. So many relaxations have been granted to one-person company in compliance with procedural aspects, because this is not a public company, this is a private company, and we know there are certain privileges available to a private company as compared to public company. So one person company is also considered as a private company, because this is formed by one person as a member. Although there are other persons set aside with one person, his wife, his son and daughters, and blood relations are there. So, but this is formed by one person. So there are certain relaxations, exemptions have been granted as per the Companies Act to one-person company in respect of the compliance procedures and procedural aspects for the formation of one-person company. And for example, one-person company is not required to hold annual general meeting. That is same in the case of a private company. Private company does not require to hold annual general meetings, but that is mandatory in the case of public company, because public money is invested into the company in the form of shares, and public interest is there. So it is a duty, responsibility of the company to hold annual general meetings to inform the general public about the routine regular affairs of the company, about the future prospects of the company, about the profits and losses of the company, and about the diversification plans of the company, discontinuation plans of the company, about the sale and purchase of land and building, furniture and fitting. This should be informed. This should be informed to the shareholders of the company, owners of the company, because they are the capital providers to the company. They are the financiers of the company, investors of the company. So it is a responsibility on the part of the company. Although it is artificial legal person, but it should be informed. It should be informed. Your investors are aware that company have such branches, have subsidiaries, have affiliate companies, state companies in other countries. Without information, if you are incorporating any other company, state companies or subsidiary companies, then it is you are under civil offence, and you have to pay civil. You are undergoing civil liability and criminal liability if you are not informing your investors by giving a notice, at least 21 days notice. before holding annual general meetings, that should be informed, and that day should not be a public holiday, the day of the meeting. So at least clear 21 days notice should be issued to all the members of the company in regard to the annual general meeting. And but that is not in the case of one-person company. One-person company is not required to hold annual general meetings. That is a privilege, you can say, available to one-person company, or available to private limited company, but that is not in the case of a public company. Public company has to hold or held annual general meetings annually every year after completion of the financial year. Within 3 months, you have to hold annual general meetings to discuss the affairs of the during the year. But one-person company is relieved from this criteria, this compliance of holding annual general meetings. Then relaxation with regard to holding board meetings also. This is a part of one-person company. There are certain relaxation given to one-person company in regard to the holding of board meetings. It is to be board meeting is to be held every year or as per the requirement of the company. But there are certain relaxation. This is not mandatory at all to hold board meetings unless until it is required to hold. You have to hold board meetings. But there are certain relaxation, and preparation financial statement, cash flow statement is exempted in the case of one-person company. But you have to prepare financial statement, whether it is trading profit or loss account, balance sheet, other accounting ratios, annexures to the financial statements, annual returns you have to file, cash flow statement, fund flow statement you have to prepare it as per the accounting standards issued by the ASAI, accounting standard 3. So you have to follow the basic generally accepted accounting principles. In the case of public limited company, you have to follow all the accounting standards and procedures, accounting conventions, accounting principles for the purpose of revisions of annual accounts. But that is not in the case of one-person company. So you are exempted from this on this ground of preparation of the cash flow statement. Then signing of annual returns, you have to sign annual returns. This is we are using relaxation on this point, signing of annual returns. But annual return you have to prepare to make it as a documentary evidence to be present in the court of law in the case of any dispute. So annual return has to be signed by the members of the company, by directors of the company. If only one person acts as director of the company, that it is to be signed, and the common seal of the company is to be incorporated in the official document to make it as a valid document to be presented in the court of in case of any dispute, any controversies. You can show accounts should be prepared as per the accounting principle. This is good for you in order to avail any relief from the court of law. So these are the certain relaxation or exemptions you can say available to one-person company. They are exempted on the ground of holding board meetings, and they are exempted on the ground of preparation of financial statements, and they are exempted on the ground of signing of annual returns. Then come to the small company. Small company is a new type of company defined under the Companies Act 2013. So this is another type of company, another kind of company, another classification of company as per the Companies Act 2013. And this is also a classification of private company. This is also a private company, small company, based on the size of the paid-up share capital and turnover. On that basis, company is defined as a small company. Or there is a definition given section 2 subsection 85. Section 2 of any law, I have already told you, section 2 of any law is about definitions under the act. Section 1 is about historical background, objectives, applicability of the act. But section 2 of any act is about the definitions under the act. Just you have to remind section 85 to subsection 85 about the one-person company, about the small company. A small company means a private limited. This is a private limited company not being a subsidiary or holding of public limited company. Otherwise, it becomes a public limited company. So small company means a private limited company, but not being a subsidiary or holding company of a public limited company. Section 2, subsection 85 of the Companies Act 2013 is about the small company, and small company is also, another way you can call it as a private limited company, but it should not be a subsidiary or holding company of a public limited company. Otherwise, it is called it as a public limited company. So holding company, subsidiary company, public limited company is also called it as a public company. So because the parent company is public company, so they're holding a subsidiary, they're holding, and their subsidiaries is also called it as a public company. So, but in the case of small company means as per the definition, and it is on the basis size and paid up capital and turnover. Then small company, as per this section, should not be a subsidiary or holding company of a public limited company having paid up share capital of which does not exceed 50 lakh rupees. This is about the public company having paid up share capital of which does not exceed 50 lakh rupees, and turnover of which as per its last profit and loss account does not exceed 2 crore rupees. So these are the conditions. Of a public company having paid up share capital of which does not exceed 50 lakh rupees, and turnover of which as per its last profit and loss account does not exceed 2 crore rupees. So this is about the provisions as per the Companies Act 2013, as per section 2, subsection 85. A small company means a private limited company, not being a subsidiary or holding of a public company, having paid up share capital which does not exceed 50 lakh rupees, and turnover of which as per its last profit and loss account does not exceed 2 crore rupees. So if this limit is not exceeded, then it is called it as a small company. Small company again is a classification of company on the basis of size, and on the basis of size of the capital, and on the basis of the turnover. Then there's a question arises. This is very important. Is company a citizen? Is company a citizen? Like we are the citizen of India, the citizen of nation, citizen of any other country. Is company citizen? Although company is an artificial legal person, company does not have the characteristics of a natural physical person, but company has its identity in the eyes of law. A company can file suit in his or her name. Company can present in the court of law by its directors of the company, by its official representative. But not in physical terms, but yes, the company represents by its natural persons. Company is artificial person, but company represents by natural persons, the directors of the company, or promoters of the company, or founder members of the company. So company through a legal person is not a citizen. This is as per the company through a legal person. Legal person means artificial legal person having identity, having existence in the eyes of law, in the court of law, because it is registered body, corporate, registered as per the Companies Act, incorporated as per the Companies Act, and obtain the certificate of incorporation, certificate of commencement of business in the case of a limited company. But although it is a legal person, but it is not a citizen as per the case. This is as per the case. And this has been the conclusion of the special bench of the Supreme Court in State Trading Corporation of India versus CTO. This is two parties involved in that case. The name of case number is AIR 1963 SC 1811. So the two parties involved in this case, State Trading Corporation of India versus CTO. This is a special bench case. of the Supreme Court. And the conclusion is that the company, although it is a legal person, but company is not a citizen. The question is the company is not a citizen. Like physical, as a physical person, company is not a physical person. Company is an artificial person. If anyone represents the company in any way, it harms the image of the company in the market. Because directors of the company cannot represent itself by itself. Company represent by someone else. But the directors, they run the company. They act as agent of the company. If the agent involved in some forgery, some fudging of accounts, some manipulation, some hidden agenda in their mind, some game element in their mind, in that case, if you if you're not representing yourself in person, and if you're saying that you are a citizen means you have to present in a person. Company position is in legal in the eyes of law. On the papers, how can we say the other person represent me in a better way? Only you can represent yourself in a better way. No one can represent you. So, as per this company, to a legal person, but it is not a citizen. So, citizen means you have to be in person, you have to present in person, you have a citizenship identity. But as per this case, this is not my words, this is a judgment of the Supreme Court, a special bench. The two parties I already stated in here in this slide, Trading Corporation of India versus CTU. The State Trading Corporation of India is incorporated as a private company. This is a case as a private company under the Companies Act 1956. So, State Trading Corporation of India is incorporated as a private company, or you can say private limited company under the Companies Act 1956. This is a previous company law, that is 1956. And all the shares held by the President of India and two secretaries in their official capacities. Means all the shares of the company, the State Trading Corporation of India, is all the shares are held hold by the President of India and two secretaries in their official capacities. And the question was whether the corporation was citizen. So one of the contention put forward on behalf of the corporation was that if the corporate will is pierced, 1C, 3 persons who are admittedly the citizens of India, and therefore the corporation should also be regarded as citizen. Okay. So a company to look up is not a citizen. So, but the persons who run the company, they are the citizens. They are the citizens of India, and therefore the corporation should also be regarded as a citizen. So the judgment is that we take a company as citizen because the members of the company, the shareholders of the company, they are the citizens of India. So we incorporated that if they are citizens, the corporation should also be regarded as a citizen. You can take it as citizen, but a company to a legal person is not a citizen. So this is but this has been the conclusion of the bench as per the case. But although company, this is a judgment of the case, but company is not a citizen. Company is an artificial legal person. How can other one represent you? Don't know. You only know about yourself, how you represent yourself in front of others, in front of general public. How another person, although they are the promoters of you, they are the person behind your incorporation, behind your born, behind your birth, but you can't trust. So when you see the downfall of the company, the person engaged, they are responsible for the downfall of the company, for the discontinuation of the company, dissolution of the company. How can we trust our directors? That they are representing ourselves in a better way. Only you can represent yourself in a better way. Then keywords are there. Limited liability, and usually refers to limited companies where the shareholders liability to pay the debts of the company is limited to the values of the shares. So liability of the company although company is incorporated by legal formalities and by legal formalities, but the liability of its member is limited by nature. Whether it is a public limited company or a private limited company, liability is limited up to the extent of their amount unpaid on the paid share capital of the company. Whatever they paid, they are not responsible for that. Whatever is not paid, they are only responsible to pay that. So usually refers to limited companies where the shareholders liability to pay the debts of the company is limited to the value of their shares. So their liability, but companies' liability is unlimited. Unlimited means although company run by its members, but member liability is limited. Company has to wind up all the official procedures, official liquidation, realization of all the assets, payment of all the dues. Then company cannot stay away from the liability. I will not do anything. I will not pay. Company has to make arrangement, whether with the help of the members of the company, but company has to make arrangements for the payment of their liabilities in order to find out the procedures, winding up procedures to wind up the company. And a company cannot run away from the liability. I will not do this. I will not do this. I will not pay this. Company has to do all the legal formalities, has to file all the important documentary evidence with the ROC in order to compile the procedures that is required for the closing of the company, closing of all the books of accounts of the company, payment of all the dues of the company. But liability is unlimited, but that unlimited extent has to be explained in the article session. Although the liability is unlimited, if liability is a certain exception to the limited liability concept also. Although your liability is limited, but if your intention is to fraud anyone, if your intention is to cheat anyone, if your intention is to indulge in insider trading, and then in that case your liability is unlimited. Your personal assets can be utilized to pay out the dues of the firm, but that is this is in case of companies, liability is limited, but in the case of proprietorship and partnership, liability is unlimited, but that is not in the case of company. Liability is limited, but if anyone filed a case on you that you are indulging this transaction, you are indulging fudging of accounts, fraudulent transaction, then in that case your liability is unlimited, not limited. Meaning is that unlimited means your personal assets, your personal belongingness, your personal land can be used to pay all the dues of the firm, pay all the dues of the bank that has been utilized. But that is not in the case of limited liability concept. Limited liability means you are only liable up to the extent of unpaid capital, up to the extent of unpaid share capital amount, and not beyond.